Yes, Mr. Featherstone.
My Lords, I'm very grateful for the time allowed over the short adjournment. I think it will enable me to be rather shorter than 15 minutes. My Lords, can I ask your Lordships to turn to the record, page 51, where your Lordships will find part of the judgment, first instance below. It's paragraph 3 near the top on page 51, where the judge says the defendants own units 106 and 102. Now, 106 was owned by the first defendant, which ceased to play any part in these proceedings after the decision of the Court of Appeals. So it's only one remaining lot owner. The appellants, the defendants own units 106 and 102 respectively in the development and started letting their units on, in the case of these appellants, 2007, to the annoyance of other owners who say that they purchased homes at the Pinnacle because they were seeking a low-density residential community, which the Pinnacle was intended to be, free of the short-term holiday makers typical of the vacation resorts on the island. So, my Lords, that was the conceptual target of these bylaws, for better or for worse. That was what this particular development was marketed as, and it was the basis upon which all the lot owners acquired their lots, a low-density residential community free of short-term holiday makers. Now, there are a number of ways in which that conceptual target could have been met through the bylaws, and your Lordships heard, by way of concession this morning from a learned friend, what wording would have been unexceptionable. The first was the one, I think, given in answer to my Lord Kerr's question, what about use other than by the proprietor or his guests? Not to use other than by the proprietor or his guests for holiday purposes. And Mr. Tom accepted that that would be a bylaw restricting use but not dealing. That would be harsh in my submission, a bylaw worded in those terms, because it would prevent all proprietors from gaining an income from holiday letting. And it would also be very hard to enforce, because there would be arguments about whether the barrister who turns up for a week with his work and is there for a holiday but does a bit of work in the evening is using for holiday purposes or not. One can think of lots of penumbral uncertainty with drafting of that sort. So that wouldn't really be a very good solution, a very good way of achieving the conceptual target. The second alternative, which was put by my Lord Sumption, is a bylaw saying you cannot use for business purposes unless it's for over a month, a letting of over a month. And again, I think my learned friend accepted that a bylaw worded in those terms would be enforceable because it's aimed at use and not at dealings. But it still cuts out, it goes far wider than it needs to, and it's not nearly as sensitive in its impact as the bylaw in this case. Ours, in my submission, is better and fairer. It was accepted as a perfectly good compromise by the overwhelming majority of the 34 lot owners. And its effect is to prohibit use that is commercial business use, or read holiday, other than by the proprietor or his guests. And, my Lords, one only gets into difficulty with bylaw 9 if one passes it into its separate parts and looks at the first sentence by itself. And in my submission, that is not the way in which one should approach bylaws dreamt up by private parties, as in this case. This is not a statute. Read as a whole, what bylaw 9 does is to achieve broadly the same aim as those other formulations, but in a rather more delicate manner. It eliminates casual holiday traffic. That's what everyone's signed up to. and it is the original bylaw that everybody signed up to. And in that connection, can I just take your lordships briefly to one further, my last authority. It's in volume 2, behind tab 23. It's the decision in Casuarina of the Court of Appeal of New South Wales, starting at page 1462, sitting Justices of Appeal McFarlane and then those two great equity judges, Young and Handley. And the decision was given on the 24th of June 2011. Can I invite your lordship's attention straight to page 1467, at the beginning of the judgment of Justice McFarlane, the bottom of the page, and then straight to paragraph 6 of his judgment, where he says, in conclusion, I emphasise that the present case is concerned with the powers of an owner's corporation to make an original bylaw. Thus, all owners would have been, or at least should have been, aware of the terms of the relevant bylaw at the time they purchased their units. Accordingly, its terms can be assumed to have been a matter that they took into account in deciding to purchase the units. And then the judgment of Justice Young starts. And can I just very briefly go to page 1478, paragraph 50, where he says some very different considerations arise when one is considering whether an original bylaw is valid as opposed to an amended bylaw. In the case of an original bylaw, people have vested rights which are not likely to be diminished by an amendment at the behest of the majority, still less the minority as it would be in this case.
How does that impact on the cold question, whether a bylaw offends section 20 sub 4, which appears in its language to be blind as to whether it's original or substituted?
My Lord, I quite take the point. I think all I'm saying is that in the same way as I urge upon your lordships not to construe these bylaws as if they're statutes and to pass them down to their elements, in the same way as that, I say your lordships should pay deference to the fact that these were original bylaws willingly signed up to by the original owners who have vested rights incorporating these. But I don't go as far as saying, of course I don't, that your lordships should, because these are original bylaws, ignore the ordinance. Of course I don't say that.
Does it have any significance in law? I mean, I can see the sort of the emotive effect of it, and indeed the very practical effect from the point of view of the people who signed up to it, but does it have any relevance in law?
Well,
no, I'd like to know if it does, what it is.
Well, my Lord,
because it's not contract, it's not estoppel. It's simply a question of construction of the bylaws in the context of a statute.
Lord, I think the answer to that is this. Strata title and bylaws are regarded as a rather odd hybrid animal in the Commonwealth, and no doubt will be here too when Commonhold is more widely adopted. They are regarded as private legal systems enforceable as a matter of contract through the bylaws, with the ordinance having, as it were, a supervisory role. But where it is the original bylaws that are being scrutinised, they are accorded rather more deference. And, my Lord, I don't know quite how to suggest that that translates into the interpretive exercise, other than to say that your lordships should deal with a relatively light touch with the propositions being advanced by my learned friend this morning.
Does the Western Australian Law Commission say anything about that? I mean, I see they did a very full report on Strata.
My Lord, no. So, my Lord, that's all I wanted to say about that authority. Can I leave your lordships with this thought? I don't want to go back to Allnat and Newton, but given that my learned friend's fallback position, as it were, is to say you should strike bits of this bylaw out or ignore them as being contrary to section 20 subsection 4 and therefore of no effect, there is, if your lordships are tempted by that, there is a rather more a rather fairer way of doing that. And can I ask your lordships to look for this purpose back at the bylaw itself in the record, starting at page 106. Sorry, it's 206. So 206 is the beginning of the bylaws with a list of definitions. And your lordships find proprietor at the top of the page, and then residential strata lot means a strata lot which is intended for use as a residence. And if your lordships keep that concept in mind, intended for use as a residence, it says nothing, it doesn't qualify that in any way by saying as a residence for the proprietor, and then go to page 214 where your lordships find 7.19. As I understood my Lord Briggs's point this morning about just keeping to the first sentence, and that in itself would take effect as a restriction on dealing, because it would mean in practice no letting could be allowed at all. The offending words which produce that result are the words in the second line of the proprietor, and one might add in, just for the sake of neatness, or for accommodation of the proprietor's guests and visitors. Now, if those words were excised or regarded as being contrary to section 20 subsection 4, one would be left with, in the first sentence, the words not use or permit his residential strata lot to be used other than as a private residence, full stop. And then the second sentence would come in. And, my lords, the effect of that excision would mean that you would keep the essence, the conceptual target that these strata lot owners were aiming at. You wouldn't do anything that was contrary to section 20 subsection 4, and you would have the second sentence still providing its alleviation from effectively the ban on commercial use. And my lords, I'm anxious to assure your lordships I'm not trying to bargain with the words. I'm merely saying if your lordships are minded to go down the route of saying some parts of this bylaw are offensive but not others, then that provides the convenient solution that your lordships may find meet the justice of this particular case.
Can you help me? I mean, that's completed that point.
That's it.
Can you help me on clause 16?
Yes.
Other than the periodic renting or leasing, what is that talking about? I mean,
Well,
did you suggest there's any difference between renting and leasing, or they're the same thing?
No, I don't think that can be right. I don't think it's making a distinction between a tenancy and a lease.
As far as I can see, it can only be referring back to a, quote, renting or leasing, which is permitted by clause 9.
Yes.
And it's assuming that may be a sort of a form of business, that is a business of residential.
Well, yes.
Otherwise, it wouldn't be there at all.
That's right.
So that is really what it's about. It's
Yes.
about clause.
My lord, I think that must be right. Yes.
Thank you.
Thank you very much.
My lord, thank you.
Mr. Griffiths?
I have nothing to add, my lord.
Thank you very much. Mr. Tom?
My lord, just 2 or 3 very brief points by way of reply. First, it is my position, to clarify it, that if the whole of the second sentence of 7.1.9 comes out, and the consequence is that there can be no leasing whatever, then it is our position that that would be a prohibition on leasing in substance and would fall foul of section 24, even though it is in fact worded as a restriction on use. That goes back to our submission that it is the substance, not the form. And apart from the matters that are set out in the written case in support of that proposition, the fact that what the section 24 says in terms is that no bylaw shall operate to restrict, among other things, leasing, indicates that it is the effect that matters. My lord, the second point is that my learned friend refers to the target as he derives it from paragraph 3 of the judge's judgment at first instance. But on the other side, it is clear from, for example, the rental programme document I took your lordships to this morning, and the fact that the bylaw is littered with references to the tenants of the strata lot owners, that it was always understood there would be leasing. Where my clients went wrong is in the 21 days as opposed to the month. That's the narrowness of the issue between us. And in my respectful submission, any solution which tries to tie this, make this strata lot, strata property, the equivalent to the burn strata property, where the court held in terms that it had to be somebody's sole or main abode, sole or principal abode, cannot be consistent with not only the bylaws themselves and the way in which the property was marketed, but also the zoning and the development order and so on, all set out in the written case. And finally, in our submission, the concept of deference has no application to Section 24 at all. The sole question is this a restriction on leasing? And if it is, then it fails to operate. If it isn't, then deference doesn't matter because it isn't relevant, it isn't needed. Where deference would have, in our submission, a genuine part to play is, for example, in New South Wales, a bylaw can be struck down on the grounds that it is unreasonable. Well, clearly it would be relevant to reasonableness if everybody had signed up to it, because they might argue afterwards that it wasn't reasonable, in which case you'd say, well, why did you sign to it? Not as a matter of estoppel, but just as a matter of supporting the valued judgment. Is it reasonable or not? My Lord, those are my submissions in reply.
Thank you very much. We are grateful for the submissions. The board will take time to consider what advice they will humbly tender to a magistrate, and when the opinion of the board is promulgated, we will stipulate a time within which submissions and costs should be made. We are adjourned.